live Facebook from Radio Newman PC. We're going to answer some of your questions about immigration. Along with me is Emily Newman, my business partner. We are from Radio Newman PC. Our office has been established in 1997. Emily Newman is a partner in this office, and she also blogs at immigrationgirl.com. So if you want any quick updates that you needed whenever any update comes in, she does update in immigrationgirl.com. Emily, any news on the student visas? As you know that people are panicked with regards to the lottery system. Now, there is a new memo that was issued on May 11, 2018. You did publish on your website. Can you elaborate more on how it's going to affect the students and how you have seen the USCIS interpretation before, and what do you expect after this memo interpretation?
Right. This is a very important policy change from USCIS. It's not final yet. They have posted it for public comment for 30 days. It's a little bit of an odd situation because it's not a regulation, so they don't have to go through the regulatory notice and comment period, but it is a policy memo that they are allowing 30 days of public comment before it becomes final. So what this policy memo does is change the point in time when a student could potentially become unlawfully present. Now, unlawful presence generally is like an overstay, meaning you stayed longer than your I-94 allows you to stay. That's just in general immigration terms. The difference with students is a lot of times, most of the time, they're not given a specific date on their I-94. They're given duration of status. Meaning that as long as they're going to school and complying with all of the requirements, their status continues and they can't overstay. There's no possible way for them to become unlawfully present unless an immigration judge or USCIS tells them you are unlawfully present because you failed to maintain your status. That's the current rule. The new rule, potentially going forward starting in August, says that you can be unlawfully present if USCIS determines there was a status violation, but the day they count unlawful presence from is going to go backwards to the day the violation occurred. So right now, unlawful presence for students begins the day USCIS tells you you're unlawfully present. It could have been for a violation that happened a year ago, but they don't count unlawful presence until the actual date of that notice. Now, they're going to give you the notice today, but they're going to say you violated something a year ago. You've been unlawfully present for the entire last year. Now, it seems pretty unfair because you're not put on any notice, and on top of that, USCIS changes what is considered a violation for students without telling you.
What is considered to be legal today they can go back in future and say that that's not documented now anymore.
Exactly. We've already seen that twice just in the last couple of months here with USCIS now saying they changed their interpretation to where if you previously used up all of your practical training time and you go back to school for the same degree level, now you're not allowed to get additional practical training time, CPT. Even though you were authorized by your school to get CPT, USCIS is saying, no, that's a violation of status. And if that's the case, they could say you've been unlawfully present even though you were authorized. Another example is the STEM OPT, where USCIS just posted on their website randomly one day that all of a sudden STEM OPT does not allow third-party placement. Well, the STEM OPT regulations came out in 2016. Why did they wait until 2018 to tell us that you can't work at a third-party site? Are they going to say everyone from the past 2 years has been unlawfully present because they've been violating a rule they didn't know existed?
Looks like Trump administration can do that too.
Right, and what the big takeaway is, you want to always be sure, number one, that you're in compliance, but if for some reason you fail to maintain your status and you're determined you're unlawfully present, you cannot cross 180 days of unlawful presence If you do, when you leave and try to come back, you're going to be barred for 3 years. And if you've stayed for a year, between 180 days and 365 days, it's 10 years. And if it's over a year, it's a permanent.
If it's 360 days, it's 10 years bar. If it's less than 180 days, there is no bar. But if it's more than 180 days, it's a 3-year bar. And if it's 360 days, 10-year bar. What are you saying, Emily, is that with the new interpretation of the USCIS on the 983 form, and you're telling me, or you're telling the audiences, they can go back and determine that these people were working undocumentedly and bar them for 10 years because they have been working on a third-party placement for more than 360 days?
That's my fear.
Yikes. That's going to be a big problem for a lot of people. As you're already aware that in the 9.8, recently, as Emily was pointing out, that the USCIS updated the website. Now, they didn't update the regulations. It's not the rules or regulations, it's just the website that they updated that you cannot work at a third-party placement. Emily, have you seen any enforcement on this at this point of time?
No, I have not yet.
Have you seen any RFEs that you have received in the new quota on issuing, particularly on the third-party location?
No, not when they're talking about STEM OPT third-party placement.
Emily, you pointed on the previous last week that you have received RFEs for the new quota, even though there is no premium processing. Anything you want to, have you noticed anything odd in the request for further evidence on the H-1Bs that you have noticed?
As of this point, generally they're the same as last year. Questioning specialty occupation, questioning availability of work for the full period of time requested. Those are the most common issues. If there's third-party placement, they're questioning right to control in the employer-employee relationship. I have seen on a number of requests for evidence, they're asking about maintenance of status, particularly for F1 students who engaged in OPT, STEM OPT, and CPT. They are asking for documentation to prove that all of that practical training was authorized.
So in those, you're speaking those particularly people who have used their OPT, you've used their STEM extension, now they are in CPT, they're questioning their legal status much more thoroughly than what they used to do in 2017 or 2016.
Right, and that's exactly what concerns me about this policy memo that came out on Friday. Is that policy memo specifically says they can use the information provided in response to an RFE in order to make the determination that a violation of status has occurred. So when you provide all of this documentation to prove that you are authorized to get all of this practical training time, if they disagree and determine that you violated your status by whatever they claim during this practical training time, the new policy memo now is going to say you've been unlawfully present that whole time as well.
Yikes. That doesn't sound good.
No.
Emily, I just want to update the audiences with regards to the USCIS update that came out today, that they have completed the data entry on the H-1B quota. That does not mean that by this time, if you did not receive any receipt notices, you won't receive any receipt notices, because normally it takes about 2 to 4 days for the USCIS to issue the receipt notices after they complete the data. And as of today, Emily, we have not received a single lottery rejection notice. So if your case is not sent back to you on the lottery rejection, do not expect that it's going to be coming in next 1 or 2 days. We might expect the rejection notice mostly coming next week or the coming week, but the span of the rejection of the lottery notices might go all the way to up to 30 days from the time the USCIS says the data has been completed. We have seen in some cases for a longer period of time, but 30 days is a normal time. Emily, you have been writing the blog in immigrationgirl.com that the receipt notices, the percentage of receipt notices that you have received, does it mean that we are done with the master's quota? Are we done with the bachelor's quota? Or we still have room for getting any more receipt notices?
Yeah, there's definitely still room for receipts to come in. With the data entry complete, that just means they've finished entering data and they're going to be sending out the last of the receipts. Obviously, with snail mail, those receipts can take a week or two to arrive in the mail. So it should be slowing down. I think that we may be near the end of the advanced degree cap receipt notices. We have not received any new ones in the last couple of days. I've not seen any new filing fee checks cashed. The only receipts we've been getting very recently are for the bachelor's cap. So again, it's you never know when a receipt gets delayed in the mail. You never know when a cashed check gets delayed in the bank. So all of these moving parts, there's no rhyme or reason to it. Things can happen in a different order. I got a lot of questions on my blog about, well, if I haven't gotten an update in the SEVP portal yet, does that mean my chances are gone? And we just don't know because we've never had this portal before. So we don't know how long it takes from the time the petition is selected to the time of data entry to the time the portal gets updated. Does it happen simultaneously? We have no idea how quickly these two systems talk to each other. So we just can't say yet whether you should still expect updates in SEVP just because data entry is done. Data entry being done just means that USCIS has entered the data, enough data to be able to issue the receipt. What happens after that point, nobody knows. So,
just hold on for 2 more weeks. You will probably have a very clear picture with regards to whether or not your case is getting accepted or not. We will let you know every week when we stop completely receiving the receipt notices. As of now, under the new quota, even today, we are still receiving the receipt notices. So there is still hope there, but when we stop receiving it, we will let you know. And also you can log on to immigrationgirl.com. She does update the data with regards to when she stops receiving the receipt notices. Emily, on the H-4 EAD, you have done a lot of things and it's there in the regulatory agenda in this fall. What exactly, or spring, what exactly is expected in the H-4 EAD? We know that the administration wants to put some restriction on it. How is the whole process is going to work out? Does it mean that once they issue the proposed regulation, the whole EADs will be banned? Does it mean that they won't allow the extension? How it has worked previously, and how do you expect this time to work on the H-4 EAD?
Right. So all we know at this point is we're expected to see a proposed regulation in June that would rescind the H-4 EAD. Now, a lot of people question, well, it just has certain H-4 EADs. Maybe they're going to allow it for some people and not for others. I don't think that's the case. They use the term certain H-4 EADs because that's the term that was used when they created the rule. It's only for certain people, i.e. those whose spouses have the approved I-140 or the extension beyond 6-year limit, all those requirements. So we do expect that across the board, the H-4 EAD is intended to be rescinded. Now, again, once the proposal comes, remember it's just a proposal in June, it could be delayed. I will note that it still has not been submitted to the OMB for approval.
Not yet.
So before they can propose the rule in the Federal Register, they first have to get approval from the OMB. It has not even been submitted to the OMB yet. You can see that online. You go to that website. I'm sure I'll post about it on Twitter or on the blog. But you can go to that site. You can type in Department of Homeland Security, and it will pull up all of the regulations that have been submitted to OMB for approval. It's not there yet. That approval usually takes a good 30 days. So I wouldn't be surprised if it gets delayed beyond June. That's just a guess. Going back to my original thought, once the proposed regulation comes out, it's just a proposal. It cannot change anything automatically. So even after the proposal comes out, you can still file the H-4 EAD, you can still get the renewals, you can still file new ones. No change happens just because of a proposal. It's proposed. It has not become final. Now, once it's proposed, we expect a 60-day notice and comment period where the public can comment on the proposal. Then a several-month-long period where the Department of Homeland Security will review all of those comments. Then they'll put out their final rule. That has to go to OMB again for approval, so that's a good 30 days. And then a final regulation will finally be published. In that final regulation, they generally will explain what will happen to existing people that have that benefit and when the cutoff is. And then the final rule will take effect 45 to 60 days in the future after the announcement. So all that to say, we've got a long time to go. while all of this is going on, you can continue to file. You can get the H-4 EAD approved. You can get renewals. You can file the first one. No change happens until a final rule is actually issued. That's going to be at least 8 months, I'm guessing, probably longer. And litigation is very likely to delay it even further. Now, what are we expecting when the final rule comes out? For those that have a valid H-4 EAD, our educated guess, is that they'll continue to be valid until they expire. You just won't be able to renew after that point. So again, no one's going to pull the rug out from under you overnight. It's going to take time. And those with an existing H-4 EAD, we expect will remain valid until they expire. They won't accept new H-4 EADs, and they won't accept renewals once a final rule comes out. This is just our educated guess, so don't quote me on that.
Emily, before we go to the question and answers, I want you to answer a couple of other things too. With regards to the regulatory agenda, the USCIS also pointed out, the Department of Homeland Security has also pointed out two other things. One, they want to change the definition of the specialty occupation so that only the bright and the best can be hired. What is the specialty occupation? What do you expect that to happen? What do you expect the Department of Homeland Security to do on the specialty occupation regulatory?
Well, we know that whatever they were planning to do got delayed, because originally in the December agenda, it was supposed to come out sometime in October. Now that's delayed until January 2019. Again, it will be a proposal. They'll have to go through the regulatory process, notice and comment period. Now, what do we expect? I would say nothing good. It's not going to get easier, that's for sure.
Not in this administration.
Yeah, so now the important thing to remember is that for H-1Bs, the definition of specialty occupation came from Congress. It's a law. So USCIS, Homeland Security, can't change the definition, and they're not trying to. What they are trying to do is change the criteria of how you can meet that definition. We currently have 4 criteria. You can pick one of 4 ways to prove a job as a specialty occupation by showing that the job normally requires a degree in a specific field, the industry requires a degree in the specific field, your company has had a history of hiring people with a degree in that field, or the job is so unique or complex that it requires someone that has a degree in a specific field. Long story short. So those 4 criteria are what are going to be changed, and I would expect it to be more difficult rather than easier.
Even though there are 4 different criteria, there are alternative criteria. The Congress intended to have either one of them to be satisfied to get the H-1B. We already seen the administration interpret that as if that we have to meet all 4 of them to meet the requirements. And with this regulation, I think so, it's going to be more tougher. But I do expect some litigation on this. Hopefully, so we're going to get some victories in that. Emily, the questions and answers that I received here, this guy is telling, oh, EB2, EB3 is taking a long period of time. Can I just file an EB5 and get the green card? And this is a very common question I come across with a lot of Indians, as EB2 is backlogged by many years and expected to be a backlog for almost a century for you guys to get the green card. No, EB5 is not an easy that you can sell an apartment in India, bring $500,000 here, and then you deposit it in some account, you get a green card. It is not that simple at all. If that would have been simple, it would have been more easier for a lot of Indians to get a green card. EB5 is very complex. It takes 6 to 7 years, and the percentage of success is only 15% for those people who have applied for the green card and eventually got the permanent green card. The percentage is only 15%. Because for you to get the green card, you have to prove that you have created 10 job opportunities. And if it's $500,000, you have invested in a zone that is approved by the USCIS. And a lot of these agencies that take the money from the individuals, sometimes since it doesn't belong to them, they do use the money differently. And then if something happens to the business, you are not going to get the green card. We see that a lot of times. So it's not that you just invest $500,000, you put it in a bank account or just invest somewhere in it. It's very complex. I would recommend that you sit down with a lawyer to discuss all the options that are available in the EB5. It is not an easy option for you to get a green card. But you should discuss with your lawyer what are the complexities issued. Emily, I know that a lot of people say that EB-5, they advertise in their websites, you get the green card. Is that what you see with the clients?
Yeah, I don't think so. I mean, maybe the conditional green card is somewhat easier to get, but to actually get the permanent green card after that initial period, usually we see a lot of people, there's a lot of delay, processing times are very long, the business doesn't work, there's tons of reasons why the green card eventually does not get that permanent green card. So.
And for those people who are failing to get the green card, they not only lost $500,000 to $1 million, but they haven't got the green card, and they end up to be out of status and have to leave the country. And so any step that you take towards that, you need to take very many precautions before you go into the option of the EB-5. Emily, some of the questions that came out from his. I have an I-140 approval, and can I now go back to India, and can I come back after 5-6 years? Will that be any problem for me? Can I use the old priority date?
So assuming the I-140 has been approved for at least 180 days, I think the technical answer is yes. The practical answer may be a little more difficult because it's going to depend on whether the company that sponsored you is going to stay in business that long, whether they're going to keep that job open for you all these years when you're not here, kind of out of sight, out of mind. And so it may be possible for you to come back on another H-1B and then have a new employer, file a new labor, new I-140, and keep that priority date, and then file the 485 when your priority date is current. So again, yes, technically you should be allowed, but
so Emily, what you're telling is that if you're planning to come back with the same company on the same I-140, that might be a little bit issues with using the same I-140, but you can port the date from the previous employer, even though they have withdrawn because it's been approved for more than 180 days. You can use that at a later date, at 10 years later on, and get it.
Right. You can use it to get an H-1B. Consular processing,
yes.
Get a 3-year H-1B based on AC-21, come back, file a new labor, new I-140, port the date, priority date's current, file the 485.
And Emily, actually, I got one I-140 approval yesterday where the lady went and stayed in India for 6 years and came back, and I got the I-140 approval with the 2007 priority date, which is current right now for her EB-2. Yes, you can go and come back, but if you're planning to use the same I-140 with the same company to get the green card, that might not be a workable deal. For all other things, you should be able to get those things approved, not a big issue. Can an EB-2 priority date be ported to EB-5? Yes, the employment-based priority dates can be moved from one application to another application, EB-1 to EB-3, EB-3 to EB-2. You should not have any problem in that.
Yeah, so going back to just the last question, Vikram kind of had a follow-up there. If you've got an I-140 approved in 2013 with company A, you've left the country, can you come back with company B? Even though it's been more than 6 years, yes, you can use that I-140 as long as it was approved, not withdrawn for more than 180 days. File a new H-1B, not subject to the cap. You don't have to go through the lottery. File it for consular processing. You can get the approval for up to 3 years, come back in, and then file a new labor, new I-140 with that company.
Tejal has a question with regards to, she has a bachelor's degree in computer science. What are the better ways to achieve the EB-1? I'm assuming that you're considering options of EB-1 extraordinary ability or probably outstanding researcher. Those are very tough to reach. If you have a bachelor's degree in computer science, if you take a little bit courses, it's not that easy for you to get an EB-1. EB-1A, which is also called as extraordinary ability, is reserved for the people who have real extraordinary ability in one particular field. Of course, if you're Satya Nadella or something like that, that makes the job easy for an immigration lawyer to get an EB1. But if you are somewhere closer to Satya Nadella or somebody like that, I think so it can be considered very seriously for EB1. But as a general rule, as we speak with people, as we consult with the people, it's not as easy as it sounds to you to get into EB1A or in EB1B, which is an outstanding researcher normally only reserved for people who are in the research positions. Typically, computer fields do not fall into the research field, but you might want to explore the options with a lawyer very thoroughly. In general, the answer is no.
One of the questions that we get quite a bit is for someone who's got the H-4 EAD, it's valid till say, October, January 2019. And the H-1B spouse is filing a transfer. Can the H-4 spouse file an EAD renewal along with it to get the longer validity period?
I know the rule of 120 days rule for not applying EAD extension if it falls, but when we have filed an extension along with the H-1B, EAD extension, H-4 and EAD, we have never seen a single rejection. They are approving the EADs. So if your spouse is applying for a transfer of H-1B from company A to company B, we strongly recommend to include your H-4 and H-4 EAD so that you get a longer duration. As Emily was pointing out, in June, they might come with a regulation. We don't know how the things are going to flow. If you want to take an extra precaution to file an H-4 EAD extension, go ahead, do it.
Karthik has a question about the 60-day grace period, not for OPT, but for H-1B, in the event of a job loss. When does it start? Is it the day you stop working, or is it the last day you get the paycheck?
Well, it should be the day that you stop working. And we are assuming that even though sometimes the paycheck is issued at a later date for the period of time that you work right now. Let's say the end date is May 15th. But you got a paycheck on May 20th for May 15th. The last day of work is May 15th, not May 20th. And please make a note that the 60-day rule is only applicable if your I-94 is valid. If your I-94 has expired, the 60-day rule is not applicable.
All right. Rakesh has a question about filing the 485. So his priority date's current, but he is outside the country. Can he still file the 485?
No, you cannot file a 485 when you're outside the country. In the 485 application, you're telling, I am in this country and I want to adjust the status. So if you're outside the country, you cannot do it. There are two options that you have available. One is a hard option. I will tell you, you can file a consular processing that will take a long period of time for you. The second, and that's going to make a lot of money to the immigration lawyers. though. The second easiest, best ever option that you have. I mean, come on, priority date became current. It's one of a life event. It's like if I were the person receiving it out of the country, it's like an Oscar award you're getting. And you don't want to take it? Come on, guy, please fly to USA, apply for the adjustment of status along with you and your family so that you never know when these priority dates are going to move up and down. As you notice that even in EB1, Emily, the priority date is backlogged by 6 years right now. If this gentleman got his priority date current, use it, get it, fly to this country.
All right, we have a question we've posted, I think, on our website about the recent lawsuit that was filed by some IT companies against USCIS regarding their, the third-party placement memo. Do you think they're going to be successful, or what? Can you give us an idea of what that lawsuit's about?
Emily, we had discussed with Mr. Jonathan Waston, who was the lawyer for this litigation. He was at our office. We do find him, we both find him very competitive. We do have very confidence in him with regards to the litigation. But sometimes what happens in the litigation is that the petitioners, the companies that filed, might get a compromise with the USCIS so that it doesn't make a precedent decision. The USCIS might compromise with the employees. There is a chance for it. But as far as the litigation is concerned, I do have very good confidence on Jonathan Waston. And as we met, and we had a discussion with 2 hours. And part of the discussion was about the litigation on the third-party placement. I do have confidence, but we'll have to see if the petitioners are going to compromise and get some benefit for themselves instead of getting for the society. There is a possibility they might withdraw. But otherwise, it looks good to me. We'll have to see. We're also expecting more cases to be filed on USCIS, not only on the third-party placement on the H-1Bs. We're expecting litigation on the 983 application where they updated the website. We're also expecting a litigation, of course, on the H-4 EAD. You have collected all the data to be ready to be supplied to the litigation lawyers to file it. So more litigation is about to come. I do have confidence on Jonathan Wasden, but we have to see how the petitioners are going to act on that.
All right. Krupal has a question about whether an H-4 EAD holder can pursue the employment-based green card, and the answer is yes. Your employer absolutely can file a labor certification and I-140 for you. And if you're on H-4 and EAD, when your priority date is current, you can file the 485. No issues there at all. Oh, there was another. One of the other very common questions we get is now a good time to travel and go for stamping?
No, not a good time. It's very hard to get through the hurdles of the F1, OPT, STEM extension, sometimes CPT. No, it's not a good option for you to go to travel right now. We have seen a significant amount of rejections. The drop box is not a safe option either. We have noticed that a lot of people have been called in. Also, there is a lot of limbo with regards to what Emily has pointed out on whether or not a third-party placement on the STEM extension is considered to be okay or not in the STEM OPT. We don't know if the consulate is going to take and rip apart your H-1B because you ever worked on the third-party placement. And also, please note that if you are in the CPT, I mean, if you're going there, buy one-way ticket, guys. Don't waste your ticket by buying back. If you get the visa, maybe you can come back, most probably. Please also note that if you have filed an H-1B, right now under the new quota, you cannot travel on F1 visa. That is a big no, no, no. If you ever want to travel, you better consult with your immigration lawyer. Only after that guy says you can, you should. I don't know any immigration lawyer who would say yes, but please consult with the immigration lawyer before you do.
All right. Bala has a question about the processing time for the H-4 EAD once the I-140 is approved.
If the H-4 EAD alone is filed without the H-4, it's taking approximately 100 days for the USCIS to adjudicate the application. But if it is filed along with the H-4, for example, if your spouse is an F1 or if your spouse is an H-1B and you're filing an H-4 along with the EAD, it's taking approximately 150 to 160 days for them to adjudicate the H-4 and EAD. Please note that if the H-4 EAD has been filed and H-4 is being filed along with your extension or transfer, then you will be subject to the premium processing, which is approximately 15 days. And if there is an RFE, after you respond to the RFE, the 15 days.
What do you think about filing in EB3 instead of EB2? Do you think it's going to ultimately be faster?
I know that EB3 has been moving a little bit faster than EB2. At this point of time, still EB3 is behind EB2. We have seen in cases for Chinese nationals that the EB3 sometimes is ahead of EB2. At this point of time, I would not recommend Emily to go through the extra expenditure and all the cost involved to have an EB3 also right now, unless it's coming very close. There are some alternative options. If you are with the same company, you have an I-140 approval under EB2, there are under certain conditions, we can use the same labor certification to file under EB3. You can check with your immigration lawyer on that if the same labor certification can be used. But at this point of time, I'm not considering doing EB3 when I have the EB2 approval.
Deepak has a question about the grace period after the H-1B has expired. Is there one?
Grace period? No. There is no grace period in law, guys, unless it's clearly mentioned it. We have the grace period available when it's clearly mentioned. For example, if the I-94 is valid under the new regulations that have been promulgated on January 17th of 2017, yes, you do have a 60-day. Only if your I-94 is not expired. In the student visa, when the STEM OPT or the OPT expires, you have also a 60-day grace period. But if the I-94 has expired, you do not have any grace period. You are counting your stay towards the undocumented period, which Emily has pointed out that if you do 180 days, then you have a bar for 3 years. So you be very careful if the I-94 expires. Do not take any action without consulting an immigration lawyer. I have an H-1B approval with the previous employer stamping until September of 2018. Now I have an H-1B approval until 2021. Can I travel to India and come back before September 2018? Do I need to get the stamping for the new company?
Right. So in the event where you've got a valid visa from company A and you filed a transfer to company B that has a longer validity period, your visa stamp in your passport is still good. So it's not tied to that specific company. So yes, you can go out, come back in on the old visa as long as it hasn't expired, and show your new approval notice to be granted entry for the full time of the new approval notice, even though your visa expires before that. Now, be careful, because many times we see that people do this process, walk away from the airport, and then 10 days later realize that they were only given the I-94 validity to the date matching the visa instead of the extended approval notice. So make sure you check it before you walk away, because that is an error and it's much more difficult to get it fixed once you leave the airport.
Sumit has a question. Are we getting RFEs for the H-1B transfer? Yes. Yes and yes. There are a lot of RFEs coming for the H-1B transfer. Another question that repeats all the time, I know they wanted to clear answer, Emily. The H-4 EAD, can they apply the green card without being on the H-1B at all?
Yes. Yes.
Are you absolutely sure?
Absolutely. Did you know this? You can actually apply for the green card without ever setting foot in the United States. There's no requirement that you be in any particular status or in the U.S. to be sponsored for the green card. The labor certification has no requirement about what status you're in. The I-140 has no requirement about what status you're in. So you can be on H-1, you can be on H-4, you can be outside the country and have a company sponsor you for the green card.
Also, to let you know that for the non-Indian nationals and those people who are not born in India, we actually don't even have their H-1Bs. We actually go from F-1 visa directly to green card. We bypass the H-1B. That's a waste of money and a lot of documentation. We get the labor certification approval, and luckily, since they're not born in India, their priority date is current and they get the green card. So no requirement for them to be on the H-1B at all. My wife went to India on F-2 visa, and she has applied for H-1B and it got selected in the lottery. Can she come back on F-2 visa? No. No. Because if a person is coming back on F-2 visa, the intention should be to temporarily stay in United States. That is, the purpose is for her to accompany the husband and not do any working activity. There is another application which is pending that says that she wants to work on a long-term basis, and that's been received by the Immigration Service. So that might create a problem for her to come back into the country. I don't know why people travel once the H-1B has been filed. As we have been pointing out, don't make any trip if your H-1B is pending without checking with your lawyer. I would recommend this person to contact her H-1B lawyer, Emily.
All right. Are you seeing issues with getting an extension approved beyond the 6-year limit for someone who has an approved I-140?
No. We have not seen any H-1Bs getting trouble to get the H-1B beyond 6 years. Now, we do see in general the RFEs have gone up, the rejections have gone up, and the amount of questioning has gone up, and the amount of duration that is given for the H-1Bs have been cut short in some cases. But when the I-140 is been approved, the question whether you are eligible for beyond 6 years is clearly defined in the regulation. You are eligible for the H-1B if you meet all other requirements that there is a job, the position is open for a period of time, and it requires a professional degree as a specific requirement. If you meet all those requirements, absolutely no problem in getting the H-1B beyond 6 years.
A lot of people have heard of this 240-day rule.
Yes.
What is it? And what if you're getting ready to meet the 240 days? What do you do?
This has been a big complex issue that has been daunting, particularly when the premium processing is there. If your I-94 is expiring, and if your company has filed an H-1B extension, you can only work for 240 days beyond the I-94 expiration date. In other words, if your H-1B has expired on September 20th of 2017, you filed an extension before September 20th, you only can work up to 240 days beyond the September 20th of 2017. After 240 days, you should cease working for that company. Now, there are alternative options that Emily is going to discuss with you later on though, but please remember that this 240-day rule is only applicable when you are filing for an extension. It's not applicable when you are filing for a transfer of a H-1B from company A to company B. That 240-day rule is not applicable. Emily, can you describe about the exception that's available where they can get the 240-day rolling again? How do they do it?
Right. So if you have a very long pending extension, you're coming close to the 240-day limit, the best thing you can do to continue working is to file another extension that restarts another round of 240 days. But I would urge you, don't get anywhere near the 240 days. Please upgrade to premium processing. File your extension in premium processing so you never get to that point. These processing times right now are anywhere from 6 to 12 months to get an extension approved in regular processing. There's RFEs, there's second RFEs. Don't chance it. File in premium well before your I-94 expires, so that if something goes wrong, you still have the valid I-94 and can try to file again. You can try to file a transfer, you can try to file a change of status. You have a lot more options if your I-94 has not expired. If you go beyond your I-94 expiration under the 240-day rule, and then at day 240 you end up with a denial, you are out of luck, basically. It's a lot more difficult to come up with a plan to get back into status from that point. So don't put yourself in that situation. File early, file in premium, don't even come close to the 240-day limit.
Also, Deepu asked the question of the 240-day. Can they stay in United States after the 240 days? Yes, you can stay beyond the 240 days. You are not allowed to work unless you take the other steps which Emily has pointed out, but you can stay legally in United States. That's not an issue at this point of time. Emily, the question is that Arun has this question that his I-94 H-1B expired in November of, his H-1B extension was being filed in November of 2017, and now his I-94 expired in December. He needs to respond to the RFE by June. He got an RFE. Can he now change the company to company B? Will that cause any problem?
Yes and yes. So
what do you mean? Yes, for he can change.
Technically, yes, you could file with a different company, but technically, yes, it's probably going to cause you a problem. So we generally would recommend only filing a transfer while your I-94 is valid. Once your I-94 is expired and you're now in a period of authorized stay based on the pending extension, then you try to file a transfer. That pending extension is the bridge from your existing I-94 to the new transfer petition. When you transfer, it's very, very likely in our experience that the company that filed your extension is going to withdraw, and your bridge is going to collapse. That means your transfer is very likely to be approved without an I-94 as well. Now you've got to exit the country, apply for a new visa stamp, and then come back. So while yes, you could theoretically file a transfer, very likely the in-between bridge petition is going to be withdrawn, causing the bridge to collapse, and you're going to end up with an out of I-94 at the end of it all. So it's kind of, depends on the situation, but I would generally advise against that.
I have an I-140 approved. Can I quit my job and file the 485 while I'm in India? No, you cannot file 485, you're in India. The other thing is that if the I-140 has been approved with the company, you quit the job, I'm assuming that the company is not going to cooperate for the green card process. You have to file another I-140 application with a different company so that you can retain the priority date, assuming that I-140 has been approved for more than 180 days. Mr. Bala has a very interesting question. I hope this question doesn't go to the consulate. Does bad credit history has anything to do with a visa approval? We have never seen that affecting the visa approvals yet. And don't give that idea to the consulate.
Anil had a question about a brief trip to Mexico with an expired visa and a valid I-94. Can you do that?
Yeah, we don't see that as a problem. If your I-94 validity is there and you're going to Mexico or Canada and returning back within 30 days, and your purpose of visit is only for tourism, we have not seen any problem. That's legally allowed. But please note that if you are applying for a visa there in Mexico or in Canada, that provision is not applicable, because once your visa is rejected, you cannot enter with the valid I-94. Only if you're going for a tourism, within 30 days you're going to Mexico or Canada or any adjacent countries like Bahamas, you can come back. You should not have any problem.
Right, that's called the automatic visa revalidation rule. And also I'll point out on that, if your previous visa that's expired is in another category, such as F1, and you filed a change of status, got that approved to H1, and have the valid I-94, you can still use automatic revalidation to travel and come back, even though you have an F1 visa in your passport and an H1 approval notice.
Can a H4 person own a company? Can that company file a H1B for herself? Well, the H4 EAD person can own the company. Now, the answer is no, the same company cannot file the H1B. It's just strategically no. Answer is no. Legally, it might be different, but strategically, that's not a good idea to file the H1B with the same company that you own.
I think Nitin has a question about say you've used up your 6 years in H-1B status, and now you have an I-140 approved. Maybe you're in a different status. So let's say, example,
H1 to H4 more.
Right.
Yeah.
You've used up your 6 years in H-1B, then you've switched to H4. While you're on H4, you file the labor, get an I-140. Do you have to go through the lottery to get back in H-1B status?
I have done a lot of them, and then we didn't have to go to the lottery at all. We can get the H1B. That's the good thing about the H4 EAD, that when you are in the H4 EAD, you used up the H1B, this is the time for you to file an I-140. Just in case if H4 EAD gets invalidated, you can still use the H1B. Emily, Ajay has this question. His name is put in Telugu, so you can't read that, I guess. His H1B from 2017 April is pending, and his H1B for 2018 is pending. Do I need to withdraw any of it? Well, this is not considered to be a duplicate filing according to the USCIS, because you filed last year and you filed this year. You don't have to withdraw, but I don't understand why the case is still pending from 2017. Why have you not done premium processing? I mean, if you're going to keep that case for a long period of time, who knows where the end client, how the things will change. And 2018, you're not going to do premium processing when they open the thing? I think so you're doing a wrong thing. In this case, at this point of time, if you got the 2018 selected, the first thing that I would do is that do premium processing of 2017. Get the result. And if you get the positive, then you can withdraw the H-1B from 2018 because you don't need it. If you get negative, you can continue on the H-1B on the 2018 April. But I don't see why people are not understanding that they should do the premium processing. I can tell on behalf of the client assembly, they're not scared about the 1,225. That much I can assure you. But they're just worried about the feeling that they have that in premium processing they will get a denial.
It's not the premium processing that causes the denial.
It is the people there. Yeah. Anything else, Emily? I'm an H-1B. Can I do freelance photography in US?
I'm going to say no, because that's going to be unauthorized employment. Now, can you do photography as a hobby for fun and
Yes.
not charge anyone anything?
Yes.
Sure, you can take pictures of your family and friends and post them on Facebook, all those things. But
Or
if
you can
start-
go to Telugu Cultural Association. You can take the pictures of any cultural association and Red Cross. You can do some voluntary job. But if you put an agency, a photography agency, and then you're charging for each sitting $250, that definitely is working. But if you're just going and taking as a hobby, going into the mountains and taking all those things, I don't think so. That is considered as unauthorized employment.
All right, well, I think we've got a lot of repeat questions at this time, so time to sign off for the week.
And the next week, the Facebook Live will be at 5 o'clock. We're also posting these videos in YouTube. Most probably from next week, we're going to have it from YouTube and also Facebook Live at the same time. Thank you for all your things. Please don't forget to subscribe to the Immigration Girl to get all the updates, immigrationgirl.com. And please don't forget that there is a daily conference call Reddy Newman PC hosts. You need to go to our website at RN Law Group. The timings, the phone number, and the code is given in there. Every day a lawyer from our office will be there to answer the question. Thank you guys. Thank you, Emily, for coming to the Facebook Live. Thank you.